So, hello, good morning, everybody. I will start just in time as usual. I'm German and we are always in time. What are we talking about today? I will talk about copyright law, last session on copyright law, on the topic AI and copyright law. To mention that, only to summarize what we did. We took the general sentence without justification. Information wants to be free, is free. And we searched for exceptions from the rule. One exception was trade secret, very important. And one is copyright law. We have seen that the European Commission several times tried to change the copyright system to have a system which is better fitted in the digital world. That is software protection, a very broad conception for broad protection of computer programs. They are all protected for 70 years of the death of the author, which is a long period, and every software, every digital product which contains software is as such protected by software protection. Second example from the rule is database right, especially the sui generis right. That is a protection for the substantial investment in collecting and structuring data. Very new idea, which is coming, of course, from the UK. As you have seen, investment is not a category in traditional continental Europe. So it was taken from Britain and is still valid and existing. Third exception from the rule is the acquis communautaire. I hope you've understood that the acquis communautaire is a nightmare. It's really complicated because it consists of a bundle of decisions of the ECJ and certain directive intermixing with ECJ decisions. So it's rather complicated, as Guido Westkamp has explained to us. So you have listened as well to my friend Merlin Rombach, who's tried to tell you the complex world of AI, and that's the beginning of the story. Now I'm sharing my slides. So AI and copyright law. And you remember this guy, Merlin Rombach, last week. He explained to you that when we're talking about AI, you should carefully ask what AI. There are so many AI products in the world that you have to structure them and ask the question, about what are we talking? AI might be machine learning. That's a quite old word that exists since the 80s, 90s. It might as well be LLM. LLM means large language model, like ChatGPT and the others. Merlin has already told you that large language model is not only ChatGPT, but also other products like Claude or from Microsoft or Microchat, then Bart from Google. And we are looking now to the question, what is happening in copyright? In copyright, you have to ask two questions in advance. The first question is, we call it in Germany IZVR, that means International Civil Procedure Law. who can we use, which court is responsible for deciding a matter. And dependent on the question of IZVR, the court is deciding the question of international private law rules, then because international private law is not international, nor is it private, nor is it law. Each court is trying to find a solution for deciding in which cases can we apply, for instance, German or British copyright law. And you remember this strange guy who was sitting here, myself, who has explained to you that due to the times of the Dogen in Florence and Venice, we have the principle of territoriality. That means copyright law is not valid on a worldwide basis, but in a certain territory. And to find the territory, we apply today the principle of use. In which state is the copyright used? So that means if you're using AI, for instance, on the territory of Luxembourg copyright law applies, but of course not British copyright law, and unfortunately to our Trump guys, also not the American law. So it's based on the principle where, in which country do you use copyrighted material. Of course, ChatGPT has a different opinion. We are proud nation number one, make America great again. US law, Californian law, governs these terms except for the principle of conflict of law. So they say as American law, US law throughout the world. That's a total mistake. This clause can be found in a lot of contracts, but it's invalid because it violates the principles of private international law. The second sentence is also rubbish. All claims arising out of the terms shall be brought exclusively in the federal state courts of San Francisco. No, that's invalid, because we have several rules in Europe in deciding which court can decide a certain matter. And you cannot say it's exclusively San Francisco. So when you use ChatGPT, European copyright law applies, and we have 4 questions, famous short questions in order to decide on copyright law. It's what, how, who, how, and how then. What is protected? Who is the right holder? How is copyright protected? And how then means, is there any exception which can be applied? So let me ask first what. With the word copyright entry, I mean the input. I'm talking about an input and later on an output of ChatGPT. So you have to feed ChatGPT first, then there's ChatGPT working and looking what will happen, and then after that there's an output. This input can consist of a lot of various materials, such a copyright, that means works. It can be as well performance rights, and it all depends on the question of originality. So in order to sue against ChatGPT, you have to prove that your work is copied in the system. So if you can't do it, you have to be silent. And of course, the question, is a work copied by ChatGPT? You have to check the originality. And unfortunately, we have different models. In Germany and France, we have a high level of originality required. When we have the British again, we have this sweat of the eyebrow test, where if somebody is sweating, is protected. So we distinguish between input and output, as I said. Well, that is one decision which Guido didn't mention. Unfortunately, we have a rather new decision of the ECJ, this famous Brompton case. Do you know Brompton? Too expensive for you, huh? Brompton is an expensive bike. It's a bike producer of bikes which you can fold and put in a suitcase and take the bike with you. It costs thousands of euros. And one they said, our system of constructing a folded bike is protected by copyright law. It's not protected by patent law, but as copyright law. And they asked the ECJ, what do you say about protecting a bike by copyright law? And there, the court has a pan-European decision on the question of what is original. The court said copyright protection for those articles applies to a product, and the articles can even achieve a legal technical result. It's important that the product is an original work arising from an intellectual protection. I think I will now simply what? Achieve a technical result where it is an original work arising from an intellectual protection because creation, because in the choice of the shape of the product, the author of the work expresses his creative capacity in an original matter, making free and creative choices so that that shape reflects. That is a way of describing the originality standard. So please write it down in your slides. I've integrated in my slides yesterday in order to show you that as well key commentary on the question of originality. So when you see again this description, nobody says in the description that it is a human. You need a human also. That's very important for AI. Can AI be creative? So the ECJ avoids to speak of an author being a human to decide the matter. So you have various works that might be used as an input for ChatGPT. You have literary works like books, novels, poems, plays, newspaper, paper. You have computer programs. ChatGPT might be used even to make new software. You have films, music compositions. When you see YouTube, I'm fascinating. I see it as fascinating that you have thousands of music files in YouTube which are made by AI. And they are establishing a new system for checking the GEMA because they say we have so-and-so thousands of followers, so we are artificial influencers. and we want to have money. Give us money from YouTube and the GEMA, Collecting Society. So we have paintings, drawings, photographs, sculptures, we have architecture, and we have advertisement, maps, and technical drawings, everything being possibly protected by copyright law. We have as well data in ChatGPT. Data can be protected as database work in the meaning of the database directive, but it can as well be the database sui generis right. And the sui generis right means a database is a collection of works organized and individually accessible by electronic means. So if you have a substantial investment in the way you structure data, that can be protected by database sui generis right. So there is a chance for that even ChatGPT can be seen as a database investor. We have an acquis communautaire saying who can be protected, because in that Article 2.2, there's a list of possible persons who might be protected by copyright. There is the principal director, the author of a screenplay, the author of dialogue, composer of music, and so on. When you have solved the issue, what is protected under copyright law in the AI world, and who is protected, then you need to solve the question, how is the protection from the extent? And we have a twofold system. You remember this nice picture I've made from 1709 compared to 789. The Queen Anne Statute and the French Revolution, with the Declaration of Rights. The French invented the moral interest of the authors. So, if you are in an AI world, you should avoid colliding with the moral rights. One moral right is a question that the author has a right to have his name remained on the work. So if ChatGPT, for instance, abolish your name, you are mentioned as the author. That's a way. Put away, for instance, on a photograph which you made, that is a clear violation of moral rights. So ChatGPT has to respect your right to be named as the author. You have as well the right to be protected against any distortion or any alteration of the work. That is even known in the United States in the Visual Artists' Rights Act. So for instance, if your photo is changed in ChatGPT and you see a totally different photo, that is a twofold violation of moral rights, because one, you are not named as the photographer, and second, your famous photograph is changed in a bad way. So you can get even twofold damages. I've made a slide in order to tell you the last cases in court for moral rights and causing problems with AI. AI has the tendency to put away all the names of the creators. So we have several cases in the US and in Britain where the creators are not recognized as such. Or, for instance, AI system like ChatGPT produce automated changes in the picture, for instance. So it's not possible change the content without the consent. The quality control. You don't recognize your own picture because ChatGPT reduces the quality of your photo. So that is again a violation of your moral rights. Then the second part of the question, how are economic rights? So you have on the one hand moral rights, then on the other hand economic rights. The economic rights gives the author the opportunity to enjoy financial benefits, get some money for it, and every state has to grant certain economic rights, like the right to reproduction. Nobody is allowed to make a reproduction of your work. So the main problem in the digital world is that the reproduction made in a ChatGPT or in a software is transient. That means it's only temporary. Of course, if you are reproducing anything on a hard disk, like a CD or DVD, that's totally illegal. But is it illegal to make a temporary copy, for instance, in a random access memory, a RAM? So we have one decision for that, that is InfoPack of the ECJ, and they say a reproduction is temporary if its lifespan is limited to what is necessary for the proper functioning of the technical process. So some copies are out of the scope of copyright law because they are necessary for the proper functioning of a computer. For instance, RAM copies, a copy in a random access memory, might be regarded as a reproduction, but the court has said, no, that's not an illegal reproduction because it's necessary for the functioning of the computer. We have, there are to a certain degree, new slides because that was really a new situation. The court, the ECJ, has decided a matter at the middle of October. Very important decision, and nobody has checked what are the effects of this decision on AI and copyright. So the question in the excellent replay was Sony. Of course, you are the Sony computer games generation. All of you four are playing computer games to the utmost, day and night. And some of you might be interested in cheating. Cheating, that means it takes 20 hours, 40 hours to be the best in a computer game. So there's cheating software which you can download, and you can say, I want to be the best from the beginning. I hate to have all these 30 levels of gaming. I want to be in the 30 levels, and to be the best. This software is, of course, most hated by Sony because it kills the fun of playing as a whole game. And they sued against the company producing cheating software and said, your software is circumventing all our creativity in the original software, because all the users can simply go to the 30th level and avoid all the other levels. So the German court, Supreme Court asks, is it a reproduction or an alteration if I'm providing cheating software? And the ECJ said, what are you talking about? What on damn are you talking about? The cheating company does not provide a copy of the original software, and the circumvention of data structures is not part of the software protection. So forget it. That is free, does not infringe the software directive. So now we have solved 3 questions. One is, what is protected as input in ChatGPT? Second question is, who is protected? The right holder, the creator in general. Third, what is protected? What can you sue for? You can sue for illegal reproduction. That's most important in ChatGPT. Now we're coming to the fourth question, how then? Then we are looking for exemptions which allow the ChatGPT to work. And we find 2 exemptions which are very important. There's one in Article 3 of the Copyright Directive, which says that you're allowed to make data mining and text mining, whatever that means. So you can make data mining, text mining. In Article 3, that's only provided for scientific research. Universities are free to make data mining as much as possible. It's not restricted to others. So you can even not override it by a contract. So it is very important for university AI. Then we have Article 4. I mentioned that. So Article 4 gives the same freedom to commercial institutions like ChatGPT. So ChatGPT is free to make data mining and text mining. As a difference between Article 3 and 4, Article 3 cannot be overwritten by contract. Article 4 can be combined with a withdrawal clause. You can write expressly a reservation for your rights in an appropriate manner, for example, in machine-readable form. So simply you can take your digital material and write on the digital material technically, I don't want my material to be seen on ChatGPT. That is valid. It's not valid in the direction of universities, but it's valid in the question of commercial institutions. And there are even a lot of tools for allowing you to make machine-readable restrictions like spawning AI. It's typical a question of nerds, of Sheldon, in your company to take your material and say, I create a robot text sentence saying, I don't want our material to be shown on ChatGPT. So then you are protected. So now a new side, I think, District Court of Hamburg. I have promised you not to talk about German cases, but this is a rare exception because the District Court of Hamburg has made the worldwide first case on the question of AI in copyright. So the case, to tell us that, was a company called Lion invented a system for scraping. That means they are combining photos on the internet and they're linking it to certain metadata. So they had a huge database afterwards with thousands of photos and a description of the photo, what can be seen. So one photographer said, no, I don't like that. I don't want to be shown on any AI tool. I want to be taken out. And he claimed, that is interesting, I have made a nice sentence in my standard terms in contractor, saying, I don't like ChatGPT and AI. I don't like it. I don't want it. That's what all. So the court had to decide, is that allowed under Article 3? So it is university who doing it. And with university, they can make data mining as much as possible. At the end, the district court said, yes, it's research and that's free. Then we had an interesting circumstance. The court wanted to say, we are proud, we are in Hamburg, we are the first to decide the matter. And they made a huge theater performance and said, at the end is Article 3. But we are now, everybody is listening to us, and we are talking about Article 4. The whole case had nothing to do with Article 4. They said, if you are thinking about it, we might say as obiter dictum about Article 4. If it were a kind of private organization, the case would be solved under Article 4. So, because they reproduced the photos for their solution, it has to do with reproduction. The works involved were photographic works, they are protected. Is it Article 4? And they said, it may be, is not 100% of data mining, it's only scraping, combining third-party content with certain description. But we can apply Article 4 at the end. Then they said, but the author has claimed that he doesn't want ChatGPT in the standard terms. Is that a reservation in the sense of Article 4? I've mentioned Article 4 only allows to make a reservation in the machine-readable matter. Is that machine-readable? It was only standard terms. So the court said a good AI system can find out even standard terms, even in any language, even if it's Ukraine, we can discover that there is a reservation, and that is a valid reservation. So at the end, they said, by the way, we don't have to do with Article 4, it's Article 3. But they said all their ideas which he had with AI. Questions, of course, are why did the court do it? Why haven't they asked the European Court of Justice for help? They could have asked. And why are they talking about Article 4, although it doesn't, the case has nothing to do with Article 4? So that's typical in Hamburg. We are like Scholz. We are like the chancellor of the Federal Republic of Germany. We can say, and that is very good. They wanted to say anything. So there will be a lot of cases coming as well. The court will go to the Court of Appeal, then to the Supreme Court, and in 2-3 years, we know what is happening. On Sunday, I got a notice. You see, that is a case from the 7th of November. And we have an US case as well. There's a case of New York Times against ChatGPT. And there, the judge, it was a very short decision of 8 pages, said ChatGPT is not copying at all. And that's true, because if you want to find out where does the content of ChatGPT coming from, you will find a lot of material which is totally anonymous. You can find out who has made it. So it's not even a question of refusing third-party content. So these questions I have found on the homepage of the Börsenverein des Deutschen Buchhandels, that is the highest institution in the area of publishers. For instance, what is remains unclear. Can somebody give a consent to a permission for data mining? Is it possible to ask as a publisher, please give me the permission for data mining? That is impossible for the years before 2013 and 2014, because a contract is not valid for new modern use. As copyright licensing does not involve all cases being used in modern surroundings. So before 2023, that is not possible, but if you are closing now a new contract with your publisher, you can give a permission for data mining. Then CC licensing. CC is a very nice, charming idea from 2 US law professors. They invented a new licensing system called CC. So take a book. You are publishing a book, writing a book. Then you are writing at the back, this book is governed by a CC licensing, a CC license called CCDA. Then it may be copied, but you want to get money for it, and you have used the abbreviation to say pre-license, but I want money. Can you use these texts, the C text, for AI? And that is possible, says the Publishers Association, but only for general Creative Commons licenses, not for CC&C. That means you're saying at the end of this book, I want to give you the free right to copy it, but no commercial use. When you are restricting your license to that, it's not possible to use the material in AI. Or, for instance, in a license called at the end CC&D, that means no modification, then it's not possible to store the material and use it for ChatGPT. CC means Creative Commons. So let us go to the output side. First, AI as such. You remember I said input, then let ChatGPT work, and then there's a certain output. So we are coming to the second part. We have just discussed the input side, and now we're discussing what is happening with ChatGPT as such. Is ChatGPT as such protected by copyright law? Very simply, quite easy, as software and as part of software protection. So it might not be easier. It's a simple software. Every software is protected by software protection, by the directive, and so no problem. So can the software with its creation, with its output, be protected by copyright law? And what you see here, already in 2008, in the InfoPact decision, the ECJ has said a work protected by copyright needs to be an intellectual creation of its author. This is one decision where the court has said we need an author. Can a machine be an author? And you see, as well been decided even in the United States. The US Copyright Law Office, for instance, denied the copyright protection for a work which was made by a computer simply because a computer cannot create. So that was even confirmed 2 years ago. The same applies for Italy. You see all the decisions are even cited there. This is a very nice way of asking the Taylor. There was a guy called Taylor. He was trying to convince one copyright law and one patent law, patent court in the world to say a machine can be creative. And he didn't succeed. So even the Federal Supreme Court in Germany has said, no, a machine cannot create. Even in Australia, in the United States, in Great Britain, is not possible. So the only remaining is AI is software as such, but the output of the software cannot be protected. So you are free to use anything produced by ChatGPT. And makes ChatGPT perfect for students who want to cheat. Because they're not cheating. You're allowed to cheat. And therefore, we are saying, please tell us when you are using ChatGPT in order to be sure what you are doing. But we cannot prohibit you from using ChatGPT. And I would say, use it, use it, use it, use it. So I will now skip that. Software protection. What is still open, if the output of AI cannot be protected by copyright law, can it be protected by neighboring rights? Neighboring rights means, for instance, the sui generis right and by database law, because in a database to do sui generis right only needs an investor in a collection of data. So if we want to write your doctoral thesis one day, please come to me quickly and say, I have found a topic, I don't know where I found it, but it's my idea. I want to write a doctoral thesis on the question of database rights and AI output. It's a new question. So, I've written a lot of slides on the database rights in the case you are writing your doctoral thesis and preparing it. We have one decision in the world who has found a solution what can be protected as output. It was the Internet Court of Beijing in November last year, and they said the input, of course, is not protected because you cannot see any input in ChatGPT. The machine, the ChatGPT software is software as software protection. The output cannot be protected because the output has no author. But there is, of course, one person who might be the author, and that is the prompt engineer. Somebody is asking the machine and for answers. And the answers might be so original, so creative, that you get a copyright for your prompting, and that means you get even copyright for the answers of the machine. It depends on the case to case. Yeah, ask, of course.
It's art that was created using AI.
Mm.
And it went up, I think it was a case where the artist, he said he prompted it so much that it wasn't an original piece. I think it was in the USA. And the US court said, no, it's not an original piece because AI created it, as we said, and because it's output, it can't be protected.
Yeah. And that's the reason why I said it depends on the case-to-case basis, because asking 5 questions, simple questions, please help me ChatGPT in creating a picture is not enough. It must be in the way the Beijing Internet Court, they had a case where somebody was sitting 2 days to find the best question being asked to ChatGPT. Then, of course, in that circumstance, you can say, I am the creator of the content afterwards. So it really depends. So the solution in copyright law for the output is your way of asking. And therefore, we have tried to make a seminar here at the ITM where you could use any ChatGPT, BART, and whatever. It was free. But you have to say, which questions did you ask the machine? And you have to send us the questions. and we have to check the question and the answers. If the combination of question and answers is creative, original, we are the first to give you a summa cum laude. That is the solution even here at the university, but they haven't understood that. So that's all for copyright law. Let us have a quick look in the world of trademark and patent. In copyright law, you need an author because copyright law is automatically granted to the author of an original work. Trademark law is a different thing. You don't need an author. That means if you're using ChatGPT, you can say when ChatGPT created a trademark, that this trademark is granted not for ChatGPT, but for using ChatGPT. The question is, can a machine be an inventor? Can a machine invent something? And then it was a new decision of the Federal Supreme Court in Germany. When you see the definitions, it says an invention needs to involve an inventive step, and inventive step is not obvious to a person skilled in the art according to the prior art. All these definitions would say you don't need an inventor in the way of a creator. A machine can be, as part of the definitions, a machine. No problem to have that. But unfortunately, the Federal Supreme Court says on the 11th of June, no, simply no. We don't want to have it. A machine can never invent, although the definitions are different. So I think that's all, yeah. I want to mention at the end a very nice article of a colleague of mine who has tried to find a solution for saying, if we allow the creation or invention of a machine to be protected, where does that change our IP system? So where, what is happening with the money of the gamer? What is happening? Do we need a separate collecting society like the gamer for machines? So quite bizarre. This colleague of mine is living in Tashkent. Some people from Tashkent are listening to us. It was Said Guliamov. I think one day he was sitting in his office and made charming ideas on what is happening in the copyright and patent law in 200 years. So a lot of things need to be changed in order to accept even machines as creators. So he invented AI personality, personality as AI as a person. He was promoting the idea of a reorganization of the legal system regarding GEMA, and he was pleading for ethical constraint in coping with AI. So if you have time left, please read that article. It's a fascinating one. I like that very much. So let me stop here. Do you have additional questions regarding copyright law and patent law? I see people distressed, tired, exhausted. So, but I don't see any questions. It's nice. I will look at the questions. New slides, I've sent them around, I think 2 weeks ago. So now I will start for a new chapter, and the new chapter is not IP law, but unfair trade law, because the second part has to do with a company who has solved all matters which have to do with IP law. So they have found the creativity in collecting data, producing software, or asking the correct questions in their prompt. Now they have the second part. In a way, they are constructing their digital products in a fair and reasonable way. So unfair trade law. I will open my slides, just a minute. So, let me start by unfair trade law or unfair competition law as it's used in Germany. Let me first describe the international law requirement. What is said in international law regarding unfair trade law? We have a Paris Convention for the Protection of Intellectual Property from 1886, quite old. In this Paris Convention, we said we need patent, trademark, industrial design, geographical indications. But the Paris Convention as well had Article 10.2 saying that the countries of the Union are bound to assure effective protection against unfair competition. Any act of competition contrary to honest practices in industrial or commercial matters constitutes an unfair competition. To say that in advance, unfair competition has nothing to do with consumer protection. We are talking about consumer protection in one of the next lessons. We are talking about B2B protection. So an honest salesman wants to be protected against an unfair competitor. For instance, mention Article 10.2, all acts to create confusion by any means, whatever, with the establishment or the goods, false allegation in the course of trade, any way of misleading in the course of trade the public as to the nature of the goods. So very broad, and you will recognize as Article 10 third, ter means third. So the countries of the Union have to provide measures to permit associations in order to help. So we have in Germany the Wettbewerbszentrale, who is responsible for fighting against unfair trade. So again, this has nothing to do with consumer protection. That is solved in Germany by the VZBV, Verbraucherzentrale Bundesverband. So there's protection B2B. So if you have a business, you can go to the Wettbewerbszentrale and say, please sue against my competitor. We have as well European fair trading principles. Important is to know we have fundamental freedoms in the Amsterdam Treaty. We have the principle of free movement of goods. So everybody who wants to buy and sell products can simply, easily buy them. We have a freedom of establishment. So you can simply establish in a country where you want to sell your products. There's the principles of free movement of services. So if you want to provide not goods, but services, you can as well provide them for free within Union. Free movement of goods, of course, leads to famous cases. You get, of course, the slides after the lecture. So you don't need to try to write any slide down. So we have important case law. For instance, the Dassel-Will case. Is it a restriction of free movement invalid and forbidden by the Amsterdam Treaty? To simply say, I don't like a certain product and I want to prohibit it in France. It may be, for instance, in the Cassis de Dijon case, you can say, I want to restrict the free movement if it has to do with public interest, such as consumer protection, protection of human health, of trade, and are all reasons why national states are allowed to restrict the freedom of goods. And that is a case which has to do with advertisement. Is an advertisement protected by the free movement of goods? Can you say, I want to have a free ad market? If we want to promote a good, we are free to provide our advertisement anywhere. In the case Keck decision, the freedom to movement of goods was also applied to measures with equivalent effects. So a sale modality which does not apply to the domestic products and products of other states, which leads to a greater burden on imported products, are forbidden as well. So, and what do we use as a standard for deciding when is a freedom of goods restrictable? Is the average informed, attentive, reasonable consumer. So, if this consumer is misled by the restriction, then it's forbidden. Then we have secondary community law. We have a lot of directives, and directive and directive and directive. And we even have first regulations. You know, regulations are more important than directive. we have, especially in the area of health claims, certain regulations. I will now talk on several regulations. The first I'm talking about is called the Regulation on Promotion of Fairness and Transparency for Business Road Users of Online Intermediation Services. Long title. It was made in 2019. So it's a so-called P2B regulation, and it restricts the freedom to use online commercial platforms. So it restricts the use of online intermediary services and the use of online search engines. And it applies the principle of saying these services are free when is a case where a service or search engine is offered to commercial users based in the EU, or when it itself offers to consumers residing in the EU. So if you have the freedom to offer your services, if you have a search engine or intermediary service open for the EU. It does not apply to B2B platforms like Amazon or Alibaba. It does not apply in the case that no commercial user is involved, or C2C platforms. It does not apply to online payment service or online advertisement tools. So, as a general principles, all the services are free, but these services have to disclose their ranking parameters. They have to say which place do you get using Google platforms or Amazon platforms. Why are you number 1 or 2 or 3? They have access to data, to give data to the users of the platform, so they can decide what this platform is doing. Here you have the disclosure of ranking parameters. The provider must disclose the ranking parameters which influence the ranking, especially the way fee payments influence the ranking. They have to provide general terms and conditions and send them to their customers. So they have to use clear and understandable formulation. They have to describe the effect on intellectual property rights. They have to inform about additional sales parameter, and they have to inform and give access to information whether and how the provider's own products are offered on the platform. So they have to explain as well when and how their services are restricted or suspended. So the service provider is obliged to provide business users with a justification for any of these decisions before imposing restrictions and suspensions. They have to disclose technical or contractual access to data in their general terms and conditions. Imagine Google opening most of their files and explaining how are the information given by the user being used in the system. That has to be explained. That's not possible. They have to provide for an internal complaint management system. So this directive is already valid and being used, for instance, in Germany. Then a second regulation is not a regulation, it's a directive from 2005 concerning unfair business practices in the internal market, so-called OCP directive. Again, it only applies to the business to consumer sector. And of course, as a directive, it needs to be implemented in national law. It has nothing to do with consumer protection. In this directive, only to say that there were certain clauses which are expressly forbidden. So, for instance, if you are using general terms and say, I give you, stop it, I give you a big liability chance to sue against me in the case our system doesn't work. So you're saying, if we are liable for defects, you can get your money back, you can ask before, repair the good, and so on. You are simply copying what is mentioned in the BGB and the Civil Act for the rights of consumers. So the repetition of consumer rights, which were only already granted by the Civil Act, is a violation of this directive. So you are not allowed to copy the rights given already by statute in the Civil Act. So the directive says in general, unfair commercial practices are prohibited. And they're providing in Annex 1 for a catalog of things being strongly prohibited. The Annex is a kind of blacklist of things which you are never allowed to do. So, for instance, claiming to be a signatory to a code of conduct and when not, or displaying a fake trust mark, false claiming of approval, bait advertising, falsely claiming limited liability, everything is forbidden. There are other bad things which are not allowed. False claims of health risk, exploiting a consumer's misfortune, special prohibition for children advertising, speaking to children. And then we have a directive, a new one for the green transitions. Only to mention that. it was a directive with clearly saying we don't want greenwashing. So if somebody is claiming that a product is helping health and climate, and that doesn't exist, that is totally forbidden. Okay. And mentioning that regulation, you see a regulation, not a directive, that's more on the transparency and targeting of political advertising. So we have a very bad situation in Germany in February, March next year. We have to elect a new parliament, and we can see already the big parties starting their campaigns, and they're collecting, for instance, all the data, address data, financial data from the local states, collecting this data in order to address their advertisement to the correct people. That is forbidden by this regulation on political advertising. I've mentioned some of the content of this. And now we are talking about AI and unfair trade rate. You will see that all these directive and regulations I've talking about do only apply partly to AI. In the AI world, we have these general principles of unfair trade, which I will explain next week. I will stop my slides now because, of course, nobody of you has the slides in advance. So my topic will start next week. I will explain to you how unfair trade regulations, directives influence the trade with AI. You will see a lot of cases where AI is used in a bad way by bad companies for their advertisement purposes. So that's all for today. I will see several guys of you on Friday in Tbilisi. I will now fly to Tbilisi, and the rest I will see again next week on Tuesday. Have a good week and a good time. I look forward
Thank you.
for you.
Bye-bye.
Bye.
Thank you. Bye.
Bye-bye.
Thanks.
Thanks.
Bye-bye.
Bye-bye.
Thank you very much. Bye.
Bye. Bye.